Hello everybody, welcome to iExamB's Legal Beat. This is Amrita, your law faculty here at iExamB. I have started a video series for all those who are preparing for Central Bureau of Investigation APP examination. All those who are preparing for this examination should definitely subscribe to Legal Bee immediately and watch all the videos of the series. मैंने 5 इम्पॉर्टेंट जजमेंट की सीरीज स्टार्ट की है एंड अभी सबसे पहले मैंने जो सब्जेक्ट पिक किया है दैट इज इंडियन पीनल कोड. इसमें मैं टॉपिक वाइज आपको 5 इम्पॉर्टेंट जजमेंट्स डिस्कस कर रही हूँ. इससे क्या होता है, हम लोग इम्पॉर्टेंट जजमेंट्स भी पढ़ते हैं एंड हमारे कंसेप्ट्स भी रिवाइज होते रहते हैं, क्लियर होते रहते हैं. वी आर एबल टू अंडरस्टैंड द इम्पॉर्टेंट टॉपिक्स फ्रॉम ईच सब्जेक्ट. Currently, I have started with IPC and I will be completing IPC in one more video. After that, I will be starting with the next topic. अगर आपने बाकी के videos मिस कर दिए हैं, I would suggest all of you to check out the remaining videos as well. Definitely, this will be a good method for comprehensive preparation for this examination. I welcome all of you to iExamB's Legal Bee. You can subscribe to our channel. If you have any queries, you can write to us on hello@iexamb.com. Call us on 9205524028 or visit our website www.iexamb.com. Check out all the courses that are available at iExamb. The first case for discussion is Prasanna Kumar versus D Lakmi 1989. इस वीडियो में मैंने जो टॉपिक पिक किया है दैट इज ऑफेंसेस रिलेटिंग टू मैरिज and also cruelty. That is of course nothing other than section 498A of IPC, a very celebrated topic. So इस area से और offences relating to marriage related जो भी judgments हैं हम लोग इस वीडियो में discuss करने वाले हैं. The first one is Prasanna Kumar versus D Lakmi 1989. In this case, the accused married for the second time during the pendency of special appeal against decree of divorce that was in violation of section 15 of the Hindu Marriage Act. So first let us understand the facts up till here, that the marriage which was done, the second marriage, that was during the appeal being pending. The appeal was pending against a divorce decree that was passed इन द फर्स्ट मैरिज. यानी कि फर्स्ट मैरिज में जो डिवोर्स की डिग्री पास हुई थी उसके अगेंस्ट अपील अभी भी पेंडिंग थी एंड स्टिल द सेकेंड मैरिज वॉज सोलिमनाइज्ड एंड दैट वॉज नॉट बाय कंसीलिंग एनी फैक्ट ऑफ पेंडेंसी ऑफ अपील फ्रॉम द गर्ल और हर पेरेंट्स. यानी कि जिस इंसान ने ये शादी की इस पर्टिकुलर केस में, उसने जो उसकी सेकेंड वाइफ थी उससे या उसकी फैमिली से ये नहीं छुपाया था दैट ऐसी कोई अपील पेंडिंग है. उन्होंने ये सारे फैक्ट्स बताए थे. सो नाउ विदाउट कंसीलिंग सच काइंड ऑफ फैक्ट्स वी कैन नॉट से दैट द मैरिज वाज डन इन अ फ्रॉडुलेंट मैनर. सो इन दिस केस it was held that no conviction could be entered under section 496 of IPC as the act of the accused was neither dishonest nor fraudulent. यानी कि भले ही वो अपील पेंडिंग थी बट स्टिल अगर हम 496 ऑफ आईपीसी की बात करें दैट इज टॉकिंग अबाउट मैरिज सेरेमनी फ्रॉड्यूलेंटली गॉन थ्रू विदाउट लॉफुल मैरिज, देन व्हाट हैपेंस in this case? What is the main ingredient of the offense? Dishonest and fraudulent act. But इन्होंने तो कुछ भी छुपाया नहीं था from his second wife or her parents, so this section is not practiced. So this is how the court has to be very vigilant and cautious in determining the ingredients, especially relating to the offenses of marriage, and more cautious in section 498A of IPC. दुर्गा चरण वर्सेस स्टेट ऑफ दिल्ली 2000 का केस है ये. In this case, the accused belonged to a scheduled tribe community. There was no notification by the central government as such that the Hindu Marriage Act is applicable to that tribe people. So, in this case, section 494 was not attracted to his marriage. This is also a different kind of judgment. I try to bring some different judgments for you so that you are able to go through and try to elaborate your thinking, brainstorm on different kind of areas. अगर कोई क्वेश्चन आता है तो आप कि आपके माइंड में ये होना चाहिए इस सब सेक्शन के लिए हमें ये अप्रोच फॉलो करनी है, एंड यू शुड बी एबल टू थिंक इन अ डाइवर्स मैनर. So for this also, judgment reading is very important. Again, the very celebrated judgment, I had to take it up when we are talking about adultery. Joseph Shine versus Union of India 2017. You have to be updated with the current state of. अगर वो offense currently वो offense नहीं है तो आपको उससे भी updated रहना ज़रूरी है. Joseph Shine versus Union of India 2017. In this case, the 5-judge bench of the Supreme Court had ruled that 497 is unconstitutional. So it was struck down. It was said that it violates women's right to equality and treats women like a property of their husbands. The wordings of this particular section especially. So the Honorable Supreme Court unanimously ruled that criminal offense of having a sexual relationship with a woman without her husband's consent was archaic and deprived women of agency. So the apex court ruled that adultery is no longer a crime. However, it still is a valid ground for divorce. So definitely it can be claimed as a relief in matrimonial cases, but it will no longer be a crime. Vishwanath Kalubhai Christie versus State of Gujarat. In this case, the deceased was a housewife and her husband was earning very meager salary. So there was evidence also that the deceased, the lady, was constantly being nagged and harassed by her in-laws कि आप जाकर कुछ पैसे कमाओ. So ये भी एक तरीके का harassment है. उसका husband meager salary पे था, इसीलिए that she's not doing any work, she's not able to earn more money. This kind of torture and harassment was also amounting to cruelty. So you can make it out that 498A is having a very broad interpretation, and the accused persons were held guilty under section 498A of IPC for this. PV Bikshi Panthi versus State of AP 1992, Andhra Pradesh. So in this case, it was held that drinking and late coming habits of the husband, ये इंडिया में बहुत कॉमन प्रॉब्लम है, all of us know about it, drinking and late coming. These habits of the husband, coupled with beating and demanding dowry, amounts to cruelty within the meaning of section 498A of IPC. So again, 498A and its scope you need to understand, and by both these judgments I am trying to point it out to you that the scope of 498A of IPC is very broad, because all these things need to be covered. Then only we can do justice with this section and the objective of this section. But I would like to add one thing, that practically there is a lot of misuse of this provision. That is true. That is why the court has given guidelines that immediate arrest should not be made in the cases of section 498A by the police. The police should see that whether really such kind of things have been done by the accused, क्योंकि immediate arrest एक kind of harassment create करने के लिए भी false complaint बहुत ज़्यादा की जा रही थी under this particular provision. So this is what is the practicality. 498A is also very important provision for all of you, exam point of view से भी. So I would suggest all of you to study the provision and also try to go through judgments and understand the scope of each and every provision of law. Thank you everybody. Have a nice day.